Madam Commissioner, these are employees of the municipality employed in the legal department. You know, Advocate Njabolo Zulu, now that you've mentioned the name. Okay, thank you.
These are public officials in a government institution, and there's nothing wrong in mentioning who wrote the letter.
Thank you, Madam Commissioner. Advocate Njabolo Zulu, in my understanding, is an advocate of the High Court. Before joining the municipality, I'm aware that he was a prosecutor at some point in the National Prosecution Authority. I think possibly he has less than 10 years in the service of the municipality. He has recently been appointed to divisional head position. After this, I think sometime early last year, he was appointed. This was in December 2013, he was a legal advisor, and then sometime last year, he was appointed to divisional head. It's called Specialized Legal Services. And then Thabo Makwiting was a legal advisor in the municipality until October 2023, where he was promoted to the position of divisional head. I'm not sure exactly what is he responsible for, but when he signed this letter, it was 2 months in the position of divisional head. If we were to ask me, Commissioner, what are my thoughts about this letter? My first thought about the letter is that they are not the authors of the letter. My first thought.
Why do you say that, and who do you think authored the letter?
I say that because they were not involved with anything that concerned the Mkonazi debacle. It is Advocate Kemi Behar who was involved with the Mkonazi debacle. I believe that the letter was prepared, whether they were involved or not, but Advocate Behar would have known about the letter and the preparation of the letter. I believe that then he would have taken leave, and then indeed these two would have signed the letter on his instructions.
In fairness to them, let me just mention part of why I say this is a nonsense document, or it doesn't make sense, at least let me say, is if you look at 346, paragraph 6, this is about the vehicle registrations, and it says, at the time of vehicle registration, the benefit would have accrued to the city had the deal been approved. So there is an acknowledgement that there was no approval, right, of the transaction. And then 2, it says the costs incurred in the registration of vehicles was a step towards obtaining the benefit on behalf of the city, right? Mm-hmm. And then you then further go on to, and so it says, let me finish off that paragraph. It will be challenging to argue that the registration costs constitute prejudice to the city. But right, we know that that was reversed, right? That registration. The registration cost should not be viewed in isolation, but as part of an entire process. And then if you go to paragraph 8, it says, the vehicles were not registered fraudulently as explained above. It is difficult to see how CAT benefited from the registration of the vehicles as they transferred ownership to the city. We know that's not true, right?
And that's the problem I have.
They were never transferred to the city.
There was never a transfer.
Okay.
There was never a benefit that accrued to the city at any given point.
Yes.
Even the paragraph 6 that Madam Commissioner was reading, at the time of vehicle registration, because by the time you register the vehicle, the ownership must have transferred. You start first with the ownership before I register the vehicle on the system. Yes. We deal with the issue of ownership, yes. You know?
Yes.
If indeed there is a donation of a vehicle, before we go and run and register this vehicle, I must first have the ownership of the vehicle. We must deal with whatever transaction that must be entered into, where indeed you transfer the ownership to me and then we register the vehicle on the system. Yes. The registration thing is a system thing. but the actual transference of ownership has not happened at any given point. And that is the nub of this problem. There was never, because the processes, and it's worse, a legal department effectively says indeed there was no compliance with the policies of the municipality.
Yes.
They agree in paragraph 7. Failure to comply with internal policies relating to donations does not translate to fraud.
Yes.
So there is a failure to comply with internal policies. So even if it does not translate to fraud, let's give them that it does not translate to fraud, but it translates to misconduct. It translates whether they were negligent in terms of their non-compliance with the policies, or they were dishonest in not complying with the policies. But there is a clear misconduct with non-compliance with policies. Now, if a legal department will write something like this, and then tomorrow we want to go and discipline employees for non-compliance with policies,
Yes.
I mean, our employees will just simply say, but why does HR want to discipline me when the legal department actually doesn't find anything wrong with non-compliance to policies? They even wrote a letter to EMPD, a legislated body that conducts investigations, that, you know what, your finding of non-compliance to policies is irrelevant. That's why, I call this a funny letter. I heard Madam Commissioner even using a nicer word of a nonsensical letter. But what does this mean, therefore? And I think the point that I wanted to raise with the Commission, Council, if I'm allowed, the way that this letter is crafted as a defense letter. This letter is crafted to say, you know what, EMPD, leave Julius alone. This letter resonates with what happened in the telephone call of the 23rd of May, 2023. In the telephone call, I was instructed, Mutluhele Julius, leave him alone. In this letter, the essence of what is here is to tell EMPD, leave Julius alone. He has done nothing wrong. Actually, if there is anybody that must be looked at, is to look at the Fleet Management Department, you must look at my PAA, you must look at SPIS, look at everybody else. Leave Julius alone.
Maybe finally, the letter says 347, at page 347, paragraph 11, it says respectfully the suggestions, and I underline suggestions, of EMPD, given such material omissions and failure to thoroughly investigate risks the city in any further processes herein. And then 12 says, please respond within the next 10 days. Now, the report that we have seen, and if you are aware of another report from EMPD, this is your chance to say. The report that we have seen doesn't contain suggestions. It contains findings and a recommendation to act. So, are you aware of another report that contains suggestions that can be responded to?
Madam Commissioner, in my history, I've never come across an EMPD report that is suggestions. I've never. A suggestion is to say change the way you're doing things and do them this way. EMPD is not that type of an institution. They would not have authority to make suggestions to a municipality.
There's no way that they could have, the author of this letter could have misunderstood that EMPD was making suggestions, at least on the report that we saw. It makes findings and recommendations of what action must be taken.
I'm trying to look for the right English word, but the closer response would be bayageza, sisgeza, and abayenzayo. I'm not sure would the right English word be they were silly. They were just being silly. Because to take it further, that paragraph 11 talks about the failure to thoroughly investigate risks the city in any further processes herein. EMPD says discipline. Discipline. That's all. And I don't know why people are so scared about discipline. You know, discipline, it's a normal process of an employment contract or of an employment relationship. Subject an employee to discipline where there are questions about the employee's conduct. That's all. Let the employee go and respond. Let it be Mkhwanazi that goes and says, you know what, there is nothing wrong. We've been doing this with my PA and peace. That's my expectation. It must be Mkhwanazi who leads that evidence in the disciplinary inquiry. He's the one that must go and tell the chairperson of the disciplinary inquiry that what is being raised with me is inconsistent with the conduct of the department, not the legal department raising that. So what would come out of a disciplinary process that risks the seat is that Mkhwanazi gets dismissed and Mkhwanazi institutes an unfair dismissal dispute. So we go and defend it.
Thank you.
There's no risk.
Thank you, Mr. Nciza.
And just to close on this, commissioners, to me, this letter on all fours is a letter that at page 348, the person who would have written this letter, all things being equal, would have been the regional secretary of the trade union. The person who would have signed here, given the content of the letter, you know, a regional secretary of a trade union would be raising all these issues to say, you are wrong, employer, you can't do this, this way, our member this, our member that. This is what this means to me. These people are just shop stewards of Mkhwanazi.
Thank you, Commissioner. Mr. Nciza, in light of those remarks in respect of IPID, I would then ask you to turn the page to page 32. You are on paragraph 104, please. 104.
Yes. Yes, thank you, commissioners. 104, I wanted to inform the commission that on the, actually it's not the 8th, it's the 22nd of March. It's just that the letter is dated the 8th, but the actual service of the letter was on the 22nd of March. And my understanding of labor law is that a termination of employment occurs upon service of the termination on the employee, not on the date that the letter is dated, because there cannot be a retrospective termination of employment. So if I may correct, the letter is dated the 8th, but the actual service of the letter via a firm of attorneys occurred on the 22nd of March 2024, and therefore my 26 years of service in the municipality was summarily terminated on that date.
It's actually dated the 7th, but it says the effective date of termination is the 8th.
Yes. That is the supposed date that the letter was signed on. And I would say it's supposed date,
the next page, yeah.
Commissioner, because on the 8th I was called, and there's an area where I actually tabulate my experiences. I was called by an inspector, I think it was De Villiers, who requested that indeed I must meet him at my offices. I must bring the office keys and I must send them over, and I must take possession of a letter. When I got there, the letter was not signed. That was on the 8th. Hence I say the supposed signing date was supposedly the 8th. But on the 8th, the letter was not signed. And De Villiers went around looking for the acting city manager and they couldn't find him. And then eventually, after about 2:02 in the afternoon, they indicated that, you know what, we can't find this gentleman, so the letter cannot be signed. When the letter gets signed, we'll indicate to you. And then 2 weeks down the line, I received the letter that was signed, dated the 8th, after 2 weeks. So that's why I'm saying it was supposedly signed on the 8th. But what is worse is the fact that the person who signed the letter on page 250 as acting city manager, because we've got an arbitration that is running on this particular issue since last year. The person who signed the letter, we discovered that his acting was from the 26th of February to the 1st of March. So by the time the person signed, he was no longer acting. That's the niceties of this place. But nonetheless, I was terminated summarily without a disciplinary hearing. There was an attempt to have a disciplinary hearing. At the disciplinary hearing, the presiding officer had made a ruling that if I had points in limine that I wanted to raise, I must raise them within a specific time period. I did raise my points in limine. The municipality was not able to respond to the points in limine. And I must say, in my view and my rep's view, the points in limine that we had raised were dispositive of the matter. But the legal representatives of the municipality, which was an attorney and an advocate, also admitted on the 26th of February that, Mr. Nciza, if these issues are not responded to appropriately in terms of historical analysis of contracts of employment, then this would be dispositive of the matter if the municipality is not able to respond.
Just, Mr. Nciza, for me to understand the timeline, what happened first?
Okay.
Between the letter we are looking at, that's PN20, and what you refer as an attempt at a disciplinary process.
Okay.
What happened first?
All
Because this letter does not, I hope I've read it correctly, it does not seem to refer to any disciplinary process. It just said, we called upon you to give us documents proving your legal qualifications. You failed to do so, you are terminated.
Yeah.
So, yeah, just the time, what happened first?
What happened? Mr. Chair, I was suspended effectively on the 7th of September, because even the representations on the suspension, when, I raised issues, they didn't consider them. I was suspended on the 7th. I was then served with a charge sheet, and there's a table where I articulate how our service was done on me. I will come to that. I was served with a charge sheet on the 23rd of January, and then we had a disciplinary hearing on the 26th of February. In between, there were all sorts of exchanges, and then the presiding officer was appointed, was an attorney, ruled that we must submit points in limine. I was supposed to submit my points in limine by the 23rd of February, which was on a Friday. And the employer was to respond on the points in limine by 5 o'clock on the 25th of February, which was on a Sunday. And then the chairperson was to make a ruling on the 26th, the Monday morning. And then we were to sit for the disciplinary hearing on the 26th and the 27th of February. I made my submission. The employer, instead of responding to the points in limine, sent an email on the Sunday. And in the email, firstly, they suggested that I had waived my right to raise points in limine, even though there was a ruling by the chairperson. But nonetheless, they said I had raised issues about contractual dispensations, and their client, which is the municipality, was not aware of these things, so they are not able to respond. We met on the 26th, which is the Monday. When we met, we dealt with the issue of the points in limine. The chairperson requested me to assist the employer with retrieving the council resolutions that I had submitted in my points in limine. There was a 2003 council resolution, and there was a 2011 council resolution. I then assisted them, went into the system of the municipality, and we did get the council resolutions. The prosecutor, the advocate, I'm not sure whether I should have mentioned names, But the advocate that was dealing with the matter then raised an issue to say these resolutions make reference to reports and there's a need for them to get the reports. So we tried to get the reports on that morning. Then there was an agreement that no, these reports are not on the system of the municipality, on the intranet. So they are archived off-site. We are in Germiston, they are archived in Birchley, Kempton Park, where there's a major archive center for the municipality. Then the municipality will go and retrieve the reports, which of course were named in the council resolution. They'll retrieve the reports, and then we should postpone the hearing to the 20th of March. All nice and nice. We agreed. The matter gets postponed. On the 1st of March, which is the Friday, this was a Monday, on the Friday, I received a letter from the municipality. I get accused in that letter that I have delayed the dismally hearing by raising points in limine. And therefore the municipality has taken the decision to put the dismally hearing in abeyance. And I must give them reasons why I should not be terminated. They list their issues about even the criminal case that I referred to earlier on. They list the issues about my advanced labor law program. And I said, fine, no problem. I'm called upon to make submissions by the 5th of March. I made the submissions. The total submissions that I made, commissioners, was 64 pages. I did a thorough, comprehensive, articulation of the issues, but then also had annexures, that even talked to what the university had provided. They did not have a problem with my law degree. They just had a problem with my advanced labor law program from UNISA. So I gave them everything that they required, in my view. Gave them everything that they required. And then on the 8th, I gave them on Tuesday the 5th, on the 8th, there was this attempt to serve me with this letter. When I took the letter, I noticed that the letter was not signed, and therefore the employee who was serving me with the letter had to go back and get the letter signed. They failed to have the letter signed on the 8th. We proceeded, because now I was not served with a termination letter, and in our understanding, the matter has not been withdrawn. The matter is still scheduled for the 20th. On the 19th, my representative sent them an email to say that the matter is proceeding tomorrow and the likes, and the attorney then responded to say, no, the 20th was a provisional date. All of a sudden now it was a provisional date, so we're going to revert to you. And then the next morning they reverted and said, no, the matter is not proceeding. Well, the matter did not proceed. And then on the 22nd, another firm of attorneys that was not part of the prosecution, but a firm of attorneys that was part of my unfair labor practice dispute on the suspension, then served me with the dismissal letter, this letter. And this letter is, of course, the subject of unfair dismissal proceedings that have been ongoing since March 2024. And I'm still busy with my unfair suspension proceedings that have been ongoing since September 2023.
Thank you.
Thank you, Chairperson.
Mr. Nciza, this process, this shorthand process where you are called upon to make representations why you should not be dismissed, and then a decision is made on that basis to terminate you, is that provided for? Is it something that is regulated by the collective agreement?
Not at all, Madam Commissioner. What they said in their letter dated the 1st of March, they invoked Schedule 8 item 4, sub-item 4, which speaks to, I think the provision is crafted might not be able to quote it verbatim, but it says in exceptional circumstances where an employer cannot be expected to follow the pre-dismissal procedures, the employer can summarily terminate the services of an employee. And I think it's a provision that I think our courts have said can be invoked in what would be regarded as war zone circumstances, like industrial action where, you know, the situation is beyond. They invoked that. They said it's exceptional circumstances. The fact that I raised points in limine. But well, it's just one of those.
All right, thank you.
Do you still have a copy of the 1st of March 2024 letter?
I have a copy of that letter, but it's not here. I have a copy of the letter. I think we can
Make it available.
We can make it available as well as the representations that were made.
Because reading the 8 March letter on its own doesn't tell the full story.
Especially when you read that I have perused and considered your representations, and that's it. Yeah, but I think can make them available.
We'll obtain a copy of that letter, Commissioner Kumar. Mr. Nciza, that then brings us to paragraph 105. You're on page 32, paragraph 105.
Yes.
Indeed. Please inform the Commission about your receipt of the report.
Yes,
cited
Commissioners.
there.
In October 2024, I was forwarded a report that is titled Forensic Investigation Report into Allegations of Defamatory Statements Made Against the City, Breaches of the Protection of Personal Information Act, and irregularities relating to the engagement and payment to attorneys, and the name of the attorneys, in and about May to August 2023. That was forwarded to me by Chief Mapie.
That report is, you'd find it on page 351 of your annexure bundle. If I can assist you, Mr. Nciza, you can also also have regard to page 370 as you deal with paragraph 107. So page 370 can assist you in giving evidence as it relates to 107.
Yes. Commissioners, at the offset, I need to indicate that, again, this is unheard of. This was unheard of. On 2 counts. Firstly, I still even have in my phone all sorts of issues that have been raised in the life of this municipality about officials in the municipality, both on social media, in newspaper articles, things that have been sent to journalists concerning employees of the municipality, inclusive of Dr. Mashaz. There is a point where there were such gross allegations that were made about corruption, tender irregularities, and all sorts of things. Beneficiation of employees and senior managers of the municipality in terms of their association with politicians, with service providers, and all sorts of things. Very, very gory things that have been said about all sorts of employees in the municipality. At no point whatsoever has the municipality ever commissioned a forensic investigation. Never. On another point, we've had instances where we would have investigations conducted, would have determinations made. Some determinations are made without even an investigation, and decisions will be taken that, you know what, we do not have a strong case, properly taken, that there's no strong case to pursue a particular cause of action. No problem. And even if you had attorneys appointed to assist the municipality in making those determinations, that has happened long before even Dr. Mashazi was a city manager. This report seeks to firstly say that there is an investigation that is conducted because of some remarks that are associated with the Bitly.Nglingi emails, the 20 August 2023 email and the 2nd September 2023 email, number one. It seeks to investigate that, who is Bitly and all sorts of things, and whether indeed the remarks that have been made by Bitly are defamatory or not. That's what that's how they've characterized the investigation. And it makes that finding that they were defamatory. However, we don't know who's Bitly. They can't find who's Bitly. But also then it goes to the Dismari hearing. And it makes all sorts of findings about the Dismari hearing. But key amongst the findings that it makes about the Dismari hearing is...
Let me assist you, Mr. Nciza.
Yes.
If you turn to page 391. 391. 391.
91.
Yes, 391 is where the heading conclusions begins.
I don't have on this bunch.
In the annexure bundle?
I don't have, unless, remember, this is not my original annexure bundle.
Let me, give me a few minutes, let me address.
Yeah.
Don't you have who's Xolani? Do you have one for yourself?
Yes, I'm in order, Chairperson. We had a spare and our attorneys are providing it to the witness. Page 391.
I'm there.
Thank you. The top of the page is titled Conclusions.
Yes.
You are then addressing the commission as regards to allegation number 3. So please just turn to page 392, allegation number 3.
Thank you. And I think, commissioners, you would have a better appreciation of the folly that exists in this report, having had the discussions that we did regarding the appointment process in terms of the disciplinary procedure collective agreement. On paragraph 13.7, it says, Nciza had, by appointing those attorneys as the city's legal representative in the Mkhwanazi disciplinary matter, without having obtained Mkhwanazi's prior written consent breached the clause 774. And when you read the clause itself that they have quoted, it doesn't say that there must be consent. It says there must be agreement as the first option. But it goes on, after saying that unless both parties agree in writing to allow legal representation, or if the presiding officer, upon receiving an application by any party, determines that it is reasonable to allow legal representation, having regard to the applicable criterion. Now, there is no requirement that must get consent. It says get agreement. If you don't get agreement, apply for legal representation. This clause, commissioners, when we negotiated, and fortunately I was part of the negotiators, we took this clause verbatim from the Rule 25 of the CCMA. It's exactly like that. Either parties shall agree or there shall be an application. So it's not saying that to get consent, but most importantly, you would not know whether indeed you are to engage with the employee before you serve the charge. I don't know whether I'm making myself clear. The way that things are done, you appoint a presiding officer and a prosecutor. The prosecutor will craft the charges. Having crafted the charges, then we serve the employee with the charges. The employee, having received the charges, would make a determination on how he wants to respond to the charges. Firstly, do I as an employee want to represent myself in a matter of this nature, given the type of charges that have been leveled against me? Do I want a shop steward or trade union organizer or official to represent me in a matter of this nature? Or alternatively, am I going to source legal representation? Now, then those are the options that are open to me as an employee. If, having due regard to the type of charges, I take a view that I'm going to sort legal representation, then when the employer comes to me and says, listen, I've got a legal representative, I want us to engage on representation. As the employee, I am better positioned to apply my mind on the provisions of 77.4 in respect of whether indeed I agree to legal representation. And if I don't agree to legal representation, it doesn't mean that the employer cannot be legally represented. It doesn't mean that. I might say I don't agree, so fine, I don't agree, then the employer must go and apply in terms of this clause. But this person that was doing this investigation, even though clause 774 is clear, he even quotes it. He then says, no, but you've breached this because you didn't get the consent of Buchanas. If indeed employers are to get consents of employees, then they will never have legal representation. And there is a point, commissioners, where indeed our collective agreement outlawed legal representation. There is a point where indeed we had said as the parties in the bargaining council, no legal representation whatsoever. But then in 2018 we brought it back because of our experiences in disciplinary inquiries, especially disciplinary inquiries of very serious and complex misconduct proceedings. And it was agreed that we are going to use the CCMA rule and convert it into a provision in the DPCA. So this is just...
If this disciplinary process had not been terminated prematurely, how would this have unfolded to get to a point where legal representation was allowed?
All right. Firstly, let me make the point that clause 7.6, this is 7.7 that talks to legal representation for employer representative, the prosecutor. But 7.6 does not talk to legal representation in respect of the presiding officer. Okay, so you can appoint an attorney to be a presiding officer. There is no application that is required there. There is no agreement that is envisaged.
Let's just zoom in on 77.4.
Yes.
Which I understand to be about legal representation for the employer or the employee.
Exactly.
So how would that have unfolded to get to a situation where there would be legal representation as envisaged?
Now, what would happen and what happens in practice is that we appoint a prosecutor. If I appoint a firm of attorneys to prosecute, because I have to appoint them, the prosecutor must generate the charge sheet, no one else. The prosecutor that is appointed is the only person that is empowered to actually say this is the charge sheet. So I can't draft a charge sheet and then after having drafted the charge sheet, serve the charge sheet on the employee, then appoint. It cannot happen that way. So we appoint, the prosecutor drafts the charge sheet, we serve the charge sheet. The employee then, even in the charge sheet, we mention that we have a right to have legal representation. So if the employee gets legal representation, it makes life easier then, because then it's easy. Both of us are legally represented. We get the agreement. We even submit it in writing that the parties have agreed, and that's it. Or the employee goes to his trade union, and the trade union can also agree that it's fine. Employer can be legally represented, no problem. But where the employee says no, I'm not agreeing to legal representation, then we make the application to the presiding officer. It is then the presiding officer, having followed the criterion that is enumerated in the collective agreement, he will then make the determination that indeed legal representation is allowed or not. If he makes a determination that it is allowed, the process continues. If he makes a determination that it is not allowed, then the process comes back to me to then make an appointment of a suitably qualified person, either in the municipality or outside of the municipality from another municipality.
So
that's how we do it.
All right. At which point, though, leave out the stage of the preparation of the charge sheet and so on, I want you to address us closer to the stage of the actual hearing. At which stage would the employee and employer have engaged each other with a view to reaching agreement or not reaching agreement on legal representation?
What we normally do, commissioners, is that we first appoint a prosecutor, and then we engage the employee at the point of we serve, then we engage the employee after serving the charges.
So it would have been at some point before the hearing?
It
would have been at some point before the hearing?
Before the hearing, yes.
Okay.
After the service, then we engage to say that, for instance, in the charge sheet, it would reflect who's the prosecutor in the charge sheet. And then the employee would know that the employer has appointed a legal representative in the charge sheet, And then we, because from the service of the charge sheet to the sitting of the hearing, there are timelines. So in that process, we get into this engagement with the employee. In most cases in the municipalities, the employee would have a trade union. I mean, in Ekurhuleni, close to about 95% of employees are trade union members. So you would then have, the employee would, sometimes you serve the employee, you also copy the trade union, the charge sheet where we've got the employee's trade union details on file. Then we are able to save the trade union as well.
Mr. Nciza,
Thank you.
and just perhaps to assist in tying up your answer to the chairperson, if you have a look at page 295 of the annexure bundle 295. Under the heading there, the employees' rights, 295, yes.
Should I read them?
you're entitled to, if yes.
Thank you. Commissioners, this is the charge sheet for Julius Mkwanazi as reflected on page 292. 295 refers to the rights. The first right is the issue of representation. The employee will be entitled to be represented at the disciplinary inquiry by bullet 1, a fellow employee of his or her choice from within the employer, or any member, office bearer or official, or the employee's registered trade union, or a practicing attorney or a practicing advocate of the High Court, or both.
And
So
if-
the employee has that right if he elects to use the right to legal representation. We don't have a problem as the employer.
And if you turn the page to 296, please. The page 296, the second paragraph starting, please take notice. Please take further
Yes.
notice.
Please take further notice that the employer appointed Mr. blah blah attorneys who have subsequently briefed blah blah advocate to initiate these disciplinary proceedings against the employee. The employer will accordingly accept service of any correspondence or process at the following address. And it lists the address of the attorneys.
Thank you. Mr.
So that effectively, firstly, gives the employee the rights, but second and most importantly, in the charge sheet, we always demonstrate as the employer who is going to be the prosecutor, and if indeed the employee then having regard to such, in practice, commissioners, employees would then also revert to the employer to say, okay, here's my rep, if it's a legal rep, these are the people that will represent me, is my trade union, and we take the process forward. We have those engagements. If indeed there's an agreement, when we go to the disciplinary hearing, as it was envisaged there, to take place on the 3rd of July, by the 3rd of July, if indeed Mr. Mkwanazi would have appointed an attorney, which was within his rights, would have then gone there to indicate that here is a written agreement between the parties, both of them are legally represented, or for that matter, you could have had a trade union rep who says, I don't care that the employer is represented by a trade union, it's not a problem. I mean, a legal rep, it's not a problem for us. It has happened as well.
But isn't there a problem with this formulation? Take an employee who is not in the know or who knows nothing at all about disciplinary processes and the prescripts applicable to such processes. That employee would not know that there is a clause 7.7.4 which says neither party can have legal representation unless there's agreement. So what your formulation or the formulation that we've just gone through now just says you are entitled to be legally represented. The municipality is already represented, and there is no indication at all that there's something like clause 7.4, 7.7.4.
Okay. Now, remember, commissioners, even if indeed you are seized with a situation where the employee is not au fait with the provisions of the collective agreement, the collective agreement says if there is no agreement between the parties, the employer then must apply to the presiding officer.
That's exactly my point. Exactly my point. The employee will not even know that there's such a process. The employee will proceed on the basis that my employer has told me that I have a right to legal representation. Mm-hmm. Let me seek legal representation. So the employee will not know that I can actually say, I do not agree that any of us should have legal representation, as I'm entitled to say so in terms of clause 7.7.4. So for that reason, unless you say something that I understand, your formulation is incorrect. You simply say you have a right to legal representation and we as the municipality are already exercising a right to legal representation. That does not speak to clause 7.7.4. Do you follow my
I follow
point?
you, Chair. I follow you, but let me put it this way, Chair. Firstly, every time we have a collective agreement, employees in the municipality are orientated on it. That's the first point. The second point is that in most instances, almost 100% of instances where we appoint legal representatives, it's for senior employees, because if indeed we are talking about employees that would not be au fait with the policy regime of the municipality, because this becomes a policy regime of the municipality, the collective agreement, that would in most cases be with your lower level employees, and unless there is something exceptional about that misconduct, we would not use legal representation for that level of employees. But we are talking here in this specific instance, a very senior employee, number one, and indeed they would know because we do a lot of workshops on the collective agreement. We even had a program where we did depot workshops. We went through all the depots and had workshops with employees so that employees know their rights, know the processes that apply to them in respect of what happens, in respect of discipline management, grievance handling, benefits administration and all sorts of things. So we put a lot of emphasis on getting employees to understand the rules in the company, Now, I understand where you're coming from, Chair, but in practice, this is what we've done, and we've done, and not only ourselves, almost all the municipalities that I'm in contact with, this is how we do it. We appoint the prosecutor who crafts the charge sheet. Having crafted the charge sheet, remember, before the service of the charge sheet, the employee is not, in essence, aware of being summoned into a disciplinary hearing. So it is the charge sheet that effectively hits the employee to say, by the way, now I'm required to interact with the employer in this particular process. So, and the person that must craft the charge sheet is the prosecutor. So, and my colleagues in the sector would say the same thing. That is how we do it. We appoint the prosecutor drafts, then indeed. The safeguard that I think the clause puts in place for the employee is that in the absence of that agreement, remember, it's not automatic that even the attorney that I've appointed is admitted into the disciplinary hearing. It's not automatic. The presiding officer still has to make a determination. And that if the presiding officer having due regard to the factors that are listed in 7.4 makes a determination that no. You know what? This is you're going overboard by appointing legal representatives. The chairperson, and it has happened, the chairperson would say, this matter is not that complex. This person is not that senior. You do have suitably qualified people that can deal with this. And indeed, if the chairperson makes that ruling, safeguarding, of course, also the interests of the employee in this particular regard, who would not have been au fait with the processes, which is very, very minimal in our situation. Then the employee, the employer would then do away with legal representation and appoint a suitably qualified internal prosecutor. That is how it has played out all along, Chair.
I don't want to belabor the point. In your introductory remarks in responding to my question, you emphasized the level of the employee or employees. My question is less about that. It is more about the prescript. Because the prescript says there must first be agreement, failing which there must be an application. So this proceeds from your formulation, proceeds from a premise that already says you are free to get legal representation. It says nothing about you are free to refuse or not to agree that either of us should have legal representation. But as I say, I don't want to belabor the point. You've given your response. Thank you.
Thank you, Chairperson. Mr. Nciza, you've had an exchange with the Commission regarding the findings summarized in paragraph 109.1 of your statement. 109.1 on page 33.
Yes.
Yes. With regard to the actual report, as it's set out on page 393, I would ask you to comment to the Commission in light of the contents of paragraph 109.2. Do you see that?
At 110?
Paragraph 109.2.
Yes.
Thank you.
Now, this finding that was made is linked to the one that says that I should have gotten prior consent before appointing the what you call the attorneys to prosecute. And unfortunately, again, it talks to how we have always interpreted this particular provision. And quite honestly, we have never actually even received a challenge that our appointment of attorneys was incorrect, and the manner in which we've appointed them, even in terms of unfair dismissal disputes that were handled by attorneys in the municipality and elsewhere. So this one then says, because we have appointed those attorneys without having received prior consent from the employee, therefore, you know, the monies, because the attorneys then submitted an invoice to the effect that certain fees were owed for the services that they rendered, the attorneys as well as the advocate, and the total value thereof was 45,470. Perhaps one of our biggest challenges, commissioners, and I'm sure that other labor relations practitioners in the sector would also have this view, because that is what we do, is if indeed it is correct that you must first get the consent, remembering that even if you don't get the consent, you can still apply to the presiding officer. So it is not automatic that legal representation is not allowed. You know, so even if indeed there was no consent, the application could still be made to the presiding officer, and that is what we always do. That even if there is no consent, we'll still apply to the presiding officer. It is the presiding officer who is seized with the matter, who then makes a determination on whether indeed legal representation is accepted or not. You know,
for the record, Mr. Nciza, I don't want you to go home on the understanding that my questions were suggesting that you should not have been assisted by attorneys in formulating the charge sheet, for example. And also, I would imagine that an application failing agreement for legal representation could be made even on the day when the proceedings are to commence. And if that is correct, if that's a correct interpretation, you would obviously be going there with your lawyers ready to run with the process in the event that the application for legal representation is successful. So don't leave this room thinking that I'm saying that you should not have engaged lawyers. I'm by no means suggesting that. It's more just about the formulation of that initial document that I'm saying perhaps there is a need for a reconsideration. That's all.
Okay.
I'm not at all saying. So I'm not saying that there was anything the matter with, for example, having lawyers in respect of whom costs to the, or costs in the amount that has been indicated ought not to have been engaged.
I get you.
Or rather that attorneys should not have been engaged with the result that the indicated costs were then incurred. I'm by no means suggesting that. I'm not there at all.
Thank you, Chair. Thank you, Chair. And I appreciate, Chair, the wisdom that the chairperson is actually sharing on this particular aspect. And I think my colleagues around the country who are observing these proceedings would also, take them to heart, take your wisdom to heart, so that indeed we fine-tune this. We fine-tune this. Thank you, Chair. But the point that I was making, Chair, is that indeed the determination that is then made by the forensic firm to say that it was wasteful expenditure to have appointed the attorneys to deal with this matter is off base, because had Mkhwanazi been charged, that he accepted the charge sheet as per any normal situation in the city, and the matter would have gone to the dismally hearing on the 3rd of July, and indeed the dismally hearing would have proceeded. We are confident, and we were confident that even in our application for legal representation would have been successful. But when you read this report suggests, Chair, that there was a withdrawal of the dismally hearing. And now we have actually dealt with the so-called withdrawal.
If I can
Yes,
assist
ma'am.
you, Mr. Nciza, page 393, paragraph 13.8.3. 13.8.3.
13.8.3. Now, this finding, Chair, that actually wants to say that the expenditure becomes fruitless because there was already a withdrawal. The expenditure is incurred before there was a withdrawal, So it cannot be that the expenditure becomes fruitless because of the withdrawal. Now, and secondly, I still maintain that there was no withdrawal of the disciplinary process. I never withdrew it as the person that had the delegated authority to establish the process. Now, and it actually, in the entire report, the fact that the charges were never served, or rather there was an instruction not to serve the charges, is not dealt with in this report, which is a critical element of how the process collapsed, so to speak. Instead, the emphasis that is put is on the withdrawal that purportedly happened on the 22nd of June 2023. I maintain that if indeed there was no stoppage of my manager from serving Mkhwanazi, there would have been a dismally inquiry and would not even be sitting discussing this report, because then the inquiry would have proceeded properly. I believe that the attorneys that were appointed would have succeeded in making a point that we indeed, must be legally represented based on the seniority of the employee and the complexity of the issues, as well as the seriousness of the allegations. So, yeah, unfortunately, again, we've got a report that is crafted. The key person who appointed and dealt with the issues is not consulted. There is no engagement. There is no request even for a submission. and adverse findings are effectively made about me without even the courtesy, the courtesy. As much as they say that I was no longer in the employ of the municipality, I can tell you, commissioners, I've had a number of instances where we have investigations, we've got processes that must be dealt with, and we have to go to a person who's no longer part of the institution and request, a submission, a statement, or whatever that will assist us to make informed decisions and to take the processes forward. We even, if indeed the person is no longer part of the institution and it's a legal process, we subpoena the person to come and provide critical information or evidence pertaining to the matter. But this report gets produced and there is no engagement at all.
Isn't the simple point, Mr. Nciza, on this, that if there was a fruitless and wasteful expenditure within the meaning of Section 78, you couldn't have been the cause of it because you didn't make the decision not to continue with the disciplinary hearing. Yet, whatever happened to it, you didn't make that decision. You didn't prevent it proceeding. It's that simple, really.
You are correct, Madam Commissioner. Actually, I think your outlook on it is spot on.
Yes.
Because indeed, if there is a fruitless and wasteful expenditure, then the persons that stopped the serving of the charges, which effectively stopped the disciplinary hearing,
Yes.
caused the fruitless and wasteful expenditure.
Yes. Thank you.
Thank you. Mr. Nciza, before we turn to the next theme, I would ask you to have a look at paragraph 110.4 on page 34, 110.4. And please make some concluding remarks to the Commission on what you believe was the true aim or the real purpose that motivated the commissioning of the report.
Thank you, Commissioners. I advance a view here that indeed, in my view, this report was procured with the main purpose of further suppressing the scandal involving Brigadier Mkhwanazi. Because we read this report nowhere, and I think at some point, Madam Commissioner, there is an interaction that we had about whether indeed there is a report that actually speaks to the merits post the Erasmus report. And I indicated that there is a report, but it doesn't speak to the merits. This report doesn't talk to the merits at all. Instead,
I thought such a report would be the 13 December 2023 report authored by the two advocates.
The one advocate.
Yeah, this one seems to be a witch hunt to look for people who leaked information to Jeff Wicks, and also to investigate whether there was wasteful expenditure. So it doesn't deal with the merits of the allegations against Mkhwanazi. It's really a witch hunt to go after people who exposed that wrongdoing.
Exactly, Commissioners. And to further illustrate that, Commissioners, I'm not sure, but I know that that article is not in this bundle. In the News City Press newspaper on the 28th of September 2025, an article was published in City Press Online, where indeed this issue of the blue lights is articulated, and the response of both Mashazi and Behari in that article quotes this report to say that Mkhwanazi was vindicated by this report. They say that, I think I even saw another article where, I think on Saturday or so, where indeed Dr. Mashazi says she had commissioned an external investigation, and that external investigation proved that Mkhwanazi did nothing wrong. I have still not seen any investigation that actually says Mkhwanazi did nothing wrong. Mkhwanazi himself, in an interview on the 25th of September 2025 with ENCA, says to the journalist there are 3 investigations that have cleared him. I liked how the journalist responds and says, no, you have not been cleared. You know, and he effectively makes reference to this report as one of those investigations. He is making reference to the letter of the 22nd of June 2023, the so-called withdrawal letter, as well as the legal department letter to IPD, that those have cleared him of wrongdoing. But in my professional expertise and experience, I have not come across any investigation that has cleared Brigadier Mkhwanazi of the actual misconduct that was alleged. None whatsoever. So indeed, I agree with you, Commissioner, that this was intended, firstly, to sanitize the blue light scandal and therefore go after, because it doesn't only go after me, it also goes after the senior management of EMPD and says they must be dealt with as well. You know, and what have they done? All they did is to investigate allegations of misconduct as what is expected of any manager. Thank you, Counsel.
Thank you, Mr. Nciza. That then brings us to our last major theme on page 34. It's titled Weaponization of the Metro Police and Labor Practices. Do you see that?
Yes, ma'am.
Thank you. Before you address the Commission on that, please have regard to the table you've prepared at paragraph 119.
Yes, ma'am.
Thank you. And that, please then use that table to assist you as you address the Commission from paragraph 111.
So I can just go through it all once.
You can summarize it with reference to the table, because the table condenses and reflects your experiences to the Commission. Thank you.
Commissioners, this theme effectively talks to the harassment that I have endured from the 7th of September until I think the 8th of March. On the 7th of September, when I was served with the pre-suspension letter that we've looked at earlier on, I was approached by 3 Metro Police officers. You recall, Commissioners, that I described how the offices are situated. I was in the building where Mr. Sheka sits, and then I was approached by 3 Metro Police officers at the parking lot. It's an open public area where I was served with a letter saying I must go home. I come from my boss's offices instead of in the privacy of an office. I was given a letter in public with Brigadier Mkhwanazi observing and monitoring the situation when I was served with that letter. On the 11th of September, in the early evenings, it was already dark, something to 7, I received a call from my wife indicating that there were police at my house with sirens and blue lights. I stay, Commissioners, in a relatively quiet suburb, Faramia in Benoni. And the street that I stay in is next to my house is a estate. You know, it has about only 4 houses. From in that block, from the stop sign up until the end of the street, my family is the only black family in that street. So you can imagine sirens and blue lights at night. Then I spoke to the inspector who was there to say, why come to my house? You know, I mean, you guys have my contact details. I'm not even at the house at that particular point. When this happens, I just left Benoni town. I was driving to a church meeting because I'm also a leader in the church. I was driving to a church meeting. I'm on the N12 going to Benoni, to Davidton. And I speak to this inspector, and he says, no, but this is the instruction we got. Sorry, DH, you know, this is the instruction we got. Got from you. From who? From Klashega, that you must come to your house at this time. I'm like, but to come and serve a letter with 4 cars. You know, you'll see on page 36, paragraph 119, that the people that were at my house were in 4 vehicles, 8 officers. All of them alighted the vehicles to serve a 2-page letter.
What are you alluding to when you mention that on your street you are the only black family?
Whether we like it or not, racial connotations exist. If indeed you are going to come to a person's house with sirens and blue lights, and you are going to see, Commissioner, as I go along, that indeed this, you know, it's a build-up. But if you're going to come to a person's house, you know, neighbors are bound to be interested in what's going on. You know, they are bound to be interested with what's happening. Oh, it's that dark, it's a haze. You know, but I'm gonna illustrate it even further with another incident. Other incidents.
I get you. I did think that's what you were alluding to.
Yes. So I spoke to the inspector and suggested to him that I am on my way to Davidton. Why don't we do this? Why don't you leave my house? Because you have no business at my house. Your business is with me. Leave my house. Let us meet at Davidton police station, you know, which is not far from my church. So we can meet there and then you can serve me. It's not a problem. He agreed. You know, because he was actually talking to me on my wife's phone and it was on speaker. So my wife is standing inside the gate, they are outside, she hears the conversation. And then hardly 5 minutes, 2-3 minutes thereafter, my wife phones back. You know, no, these guys have left. What do you mean they've left? No, after he spoke to you, he called somebody, and then I could hear him saying, okay, HOD, no, it's fine, HOD. So they were then instructed that, no, we're not going to do that. Leave that letter with the wife. So the man insisted that my wife must sign for receipt. Now, my wife has got nothing to do with employment processes. In all the 25 years of our marriage, she has never had to deal with anything that has to do with employment processes until that day.
Mr. Nciza, I mean, it may sound silly, but I imagine that this letter would have been carried by just one of the officers in the car, in one car, right?
Yes.
Physical possession of the letter.
Yes.
So you would have had 4 vehicles with 8 officers.
Yes.
There's a cost involved
Yes.
in having 4 vehicles and 8 officers coming to deliver one letter that is in one car.
In the hands
Am
of
I-
one person.
Yes, am I correct?
Yes.
Do you think that whether the HOD or whoever might have had concerns that they may not be safe when they come to deliver the letter, and so they need to come in numbers because this might have been a risky operation? Do you think there might have been a basis for that? If we try to make sense of this, which on the face of it appears like a fruitless and wasteful expenditure, actually. But if we try and make sense of it, do you think that it may have been informed by an anticipation that there might be some risk involved in delivering this to you?
If, Madam Commissioner, Kashega didn't know my house, he had never been to my house, didn't know the area that I stayed in, I might even venture such a thought. But this is a person that had been to my house. She knew exactly where I stay, the environment in which I stay. She knew me. At no point would there be a basis to believe that indeed I would pose a risk to a police officer. Police officers that I've worked with for all these years.
Thank you.
So it was not about risk. It was about humiliation.
At that stage, you were still an employee of the municipality.
I'm-
So if they wanted to serve a letter on you, they could have summoned you to the office to come and sign the letter. You were still an employee on suspension.
Not even on suspension.
Was
Remember,
this before?
Commissioner, I have not yet actually been
Oh,
suspended.
that was before, yes.
Because this now is to serve me with a
The
suspension.
suspension letter, yeah.
Exactly. You know, besides me going to their offices, and commissioners, I've dealt with service of documents. Myself, in my office, we've utilized the EMPD to go and serve documents on especially senior employees. Firstly, would have a person or 2 people in one car. There's never been a point wherein you send a squadron to an official, you know. But secondly, we would give those people that person's cell number so that they phone the person to say that, hey, we need to come and serve you this particular document that comes from HR or comes from the city manager's office. Make arrangements. Can we meet somewhere? That has always been the arrangement. We meet somewhere, you serve, they signing, and that's it. You know. But even after I'd spoken to the inspector and there's an arrangement, there is this HOD, and the only people that I can think of would have been Kashega and or Behari. But those people had said that it was Kashega that had instructed them to come to my house. I then sent, because now when my wife told me that this is what had happened, I then sent Kashega WhatsApps.
Page 396, Mr. Nciza, 396.
Commissioners, I sent 4 messages. The first message I sent was at 18:43, in which I asked the question, why send police to my house at night? And then I continue in Xhosa, utheni uhlukumeza usapho lwami? Bakwenze ntoni? Why are you harassing my family? What have they done to you? And then I sent another WhatsApp at 1846, sirens and blue lights at my house, Linda, causing a scene at my house, scaring my children and my wife. Then I sent another WhatsApp turning the Metro Police into a security branch of old, where people would be raided at night by police. Then the last one I sent was at 7 o'clock. Kulungile, akuqhutywe. It's okay, let's proceed. Now, as you can see, commissioners, all of them are one ticks. You know, all of these messages that I sent to Ms. Lasheka were one ticks.
Please forgive me for a bit of levity on something so serious. I see that 2 of the messages are deleted. Those were probably expletives.
Yeah, they were. Honestly, no, they were correct. I had written them in some rather crude Xhosa, with then I was like, no, but this is my boss, so I deleted them. Quite honestly, I was really vexed by this, Then I reflect on paragraph 115 that I sent Mr. Lasheka these messages questioning the conduct of sending police with blue lights and sirens to my house at night and thus harassing my family. Later, my wife advised me, honestly, commissioners, I was not aware. My wife advised me that if the message has one tick and you no longer can view the person's profile picture, it meant the person has blocked you on WhatsApp. I was not aware, because when I came back from church, because I proceeded, I had a church engagement, I could not just leave it. When I came back from church, and now I'm sitting with my wife and we're talking about this situation, and then I'm like, no, but dimthumele in messages. She's like, I've sent her messages, but she's not responding, and she's like, okay, let me see. I show her the phone. She's like, did you have her profile picture before this? I'm like, yes, I did. She says, you are blocked. And since that day, I remain blocked. And again, this is a suspension process, Commissioner. It's not a termination, and nowhere near termination at that stage. For my superior then to block me in the midst of this conduct, and then I get blocked. I'm like, oh, okay. Also, to just link that, on the 7th, I received the pre-suspension letter. On the 8th, when I tried to send an email talking about irregularities in the pre-suspension letter that I picked up, I discovered that I was also blocked on the email system of the municipality. I could not access the system of the municipality. So in my view, it then meant that I was actually suspended from the 7th, because we ordinarily don't block people on the system.
Just remind us, the reasons for your suspension were 2, the qualifications and you approving invoices contrary to a memorandum.
Yes.
So because of that, 4 police cars in sirens and blue lights are sent to your house.
Yes.
This is something you could have received the next day when you go to work.
Yes. The next morning, on the 12th of September, we were awakened by a siren at the gate. And this is around 6 a.m. in the morning. My third-born son was already awake, preparing to go to school, and he comes to the room. Tata, kukhona abantu ke-18. About 18, and I think at that time he was doing grade 8. So he's like, but there are people at the gate, I wake up, I rush to the gate, I find 3 vehicles, branded vehicles of the Metropolis at 6 a.m. in the morning. Again, I get into a discussion with them to say, but why? What's going on? Do you have to come at this time of the day and sound a siren? They're not only waking me up, they're waking my neighbors up. And this is a very quiet and serene street. Now, they indicated that they were instructed by Xolani to collect the laptop of the municipality at that time. I'm like, but this is not even working hours. Why specifically at this time? No, we were given instructions last night that must come here and collect this laptop.
You also mentioned that they had this time it was 3 vehicles.
3 vehicles, with 6. Each vehicle has 2 people inside it. There were 3 vehicles that came to my house at that time of the day. That is reflected on my table on page 37. Then it went
I'm
on.
suggesting, Mr. Nciza, to the chairperson that maybe you're being unfair to these 3 vehicles. The one was going to carry the charger, the other one the bag, the other one the laptop. Be kind.
It's possible, huh? It's possible. It's possible, Madam Commissioner, that my laptop is heavy, and therefore they needed 6 people to come and collect it.
I know this is serious. I don't mean to make light of it.
But again, these officers indicated, Madam Commissioner, that their actions are per the instructions to the letter of Xolani. She told them that they must come at that time. They got the instructions the previous night to say that tomorrow morning, when you come on duty, start at Mr. Nciza's house. So they clocked in at my house effectively. Then on the 10th of December, I received a call from an Inspector de Villiers who requested to meet me to serve me with an extension of my suspension. I requested that we meet at the Faramir Pick and Pay parking lot because I was at the Pick and Pay. I was busy with some groceries. And then he calls me to say, hey, Menir, I get a brief for you. I have a letter for you. Can we meet? And I know Inspector de Villiers. It's a person that I've worked with on a number of instances. And then we met. I said, you know what, it's fine. And fortunately for me, in this particular occasion, they were driving unmarked vehicles. They came, we met. Then they provided me with the letter. They were in an unmarked vehicle and they were wearing civilian clothes. But in this instance, there were 3 members. De Villiers was alone in his car, but then he was accompanied by a second car. Again, I signed for the thing, they left. The one that then became, or rather before they left, I asked the Villiers, why they need to use so many cars when they come to me. He indicated that he was instructed to use at least 2 cars with 4 members to come to me. Okay, it's an instruction. The one that commissioners, I think, was a bit, okay. Let me not characterize it. Let me just tell you what happened. On the 23rd of January 2024, there was no investigation, firstly, that was ever conducted regarding the allegations that was suspended for. No investigation. I was then formally charged in the sense that a charge sheet was brought with 4 Drug Enforcement Unit branded vehicles in the middle of the day. It was around 2 p.m.
What exactly does the branding say? Does it make reference to drugs at all, or is it just EMPD?
It's EMPD, Drug Enforcement Unit, written in big blue letters. you know. And I recall when they arrived, because they came and they did their siren thing, I came out, it was a siren thing again. It was right in the middle of the day, around 2. Came out, there were some neighbors of mine who were taking a walk. They stopped, of course, to see what's going on. And here comes this drug lord to come and receive a charge sheet from 4 drug enforcement unit vehicles.
But the charge sheet, even though it's a drug unit cars, the charge sheet still relates to the invoices and qualifications.
Exactly. You know, but in this instance, Chair, one of my neighbors actually felt the need to come and talk to me. You know, he came just to ask what's going on. You know, I was like, no, man, it's work issues. You know, it's work issues. He says, are you sure? I'm like, no, don't worry. You know, almost I work for the municipality, so no, these are my guys. You know, and they're driven off that time. I'm like, no, these are my guys, don't worry. You know, it's part of my work. You know, because I mean, clearly, if you're going to be visited by a drug unit, drug enforcement unit, it says perhaps you are part of a drug syndicate. I detail on paragraph 119 further instances in that table that on the 10th of February, again, I had people coming to my house to serve a further extension, an extension on top of the extension of suspension. And then on the 13th of February, the municipality in their charge sheet had invited me to a pre-trial hearing. I said that is not regulated by the prescripts of the DPCA, nor even the regulations on discipline, and therefore I don't see the need for us to have a pre-trial hearing. But then de Villiers, when I met with him on the very same 13th, because after I did not attend, they then sent de Villiers with a new letter where now they were changing the disciplinary procedure, because it was going to be a normal case. That all of a sudden now they want to invoke what is in the DPCA in terms of clause 9, something called the summary procedure. Yeah, clause 9, an optional summary procedure. It's on page 12 of the DPCA. They wanted to do an optional summary procedure, which would have meant that instead of having a trial type of arrangement, a proper hearing, you just simply make submissions, and the chairperson takes a decision based on submissions, of which I in any event, objected thereto. But de Villiers indicated to me that your matter is hot, yo. We were stopped from going to other operations that we're supposed to go to. We had stopped and instructed to go to the head office where the disciplinary hearing was going to be held. And 4 vehicles, their squad, was then told that they must not go to do law enforcement processes. They must come to the head office and guard the head office because my case is sitting.
Was this for the
pre-trial?
Pre-hearing?
Yeah, I was like, okay, fine. On the 1st of March, when they served me the letter contemplated termination of employment, again, 2 vehicles with 4 members. And then on the 8th of March, when they attempted to serve the unsigned letter of termination, they had 4 members and 2 vehicles. I record, Chairperson, that the total number of EMPD officials that were sent to me in the various occasions come to 48 people. And the number of vehicles that were used to serve me with single-page, two-page letters comes to 23. And it must be noted, interestingly, that all these vehicles and members, all of them fell under the command of Brigadier Mkhwanazi. It was not people from bylaw enforcement, it was not people from regional operations, it was specifically people from specialized services.
Did the drug enforcement unit also fall under
Yes.
specialized?
It also fell under Mkhwanazi. I must say that all of this was completely unnecessary and unpleasant, you would imagine. It was intended to humiliate me and my family and to cast aspersions on my person, my dignity and my character. Mr. Sheka was doing all of this knowing fully well where I stayed, my role in the community, and leadership in the church.
Mr. Nciza, ordinarily, when assuming that the employee relations or in fact even HOD, Human Resources, Xolani, is responsible for all these disciplinary processes in your absence, the serving of the suspension letter, pre-suspension, pre-termination. Ordinarily, how would you serve process on an employee who is on suspension? They are not in the office to receive the extension of a suspension because they're already at home, maybe even termination. Is there specified unit vehicles that you use? How does it work? And I ask the question to try and see if indeed anything is amiss in the fact that Mkhwanazi's section is the one that was delivering these documents to you.
Thank you, Madam Commissioner. And indeed, it's an important question that you're posing. The default position is that you arrange with the employee to come to their office, their place of work. Remember, when a person is on suspension, one of the suspension conditions is that you must avail yourself at any point the employer requires you during working hours. That's the default position. It's during working hours, and you must be available. If the employer gives you a call today and says tomorrow, and you are working at the Kempton Park Waste Depot, you are required at the office. So my team would then make that call to the employee. You are required at the office. One of my team members would then go to that depot and meet with that employee and effect service. Now, when do I use Metropolis? I use Metropolis, Madam Commissioner, when there is a senior person involved. And at Metropolis, it's unfortunate that our person that used to do this, one person, unfortunately, he had passed away, I think, early 2023. But in the course of time that I've been at DH Employee Relations, about, let's say, 6 years, there is a specific person that I had an arrangement with Metropolis that this, if I need to serve an HOD or a divisional head or somebody senior, I would not really call them into the office for service. I would not call an HOD, come to my office, I want to serve you something. I would request this gentleman who was a senior in the Metropolis Department, I think was a deputy director. I would talk to him that, hey man, can you assist us with servicing a particular letter at HOD so and so? Here is the address, here is the telephone number, can you make a call? So that he has a sense of where the person stays. Then make a call to make arrangements to meet with the person either at a restaurant or meet wherever, that the two of them would agree. That has been the norm. I would not use Metro Police officials or even this specific gentleman. And even when I use that gentleman, it's via the chief's office. You know, if the chief Mapia is not there, I would talk to Chief Mzolo, Deputy Chief Mzolo, then we'd make those arrangements. Oh, no, Xolani, it's fine, I'll talk to him. You know, I would not go directly to him. I'll talk to the chiefs. They are the ones that will then engage with him. He will call me, we'd meet. I'll give him the necessary documentation, contact details and everything. He makes that arrangement with the person. The service is done. He brings back proof of service. You know, in respect of officials lower down, no service via Metropolis, except for one. There is a gentleman who actually we had to dismiss because he was refusing. He carried a firearm to work, and he was very obstructive and very rude, insolent. We charged him, but eventually the municipality was like, this person has to go. You know, and everybody, the head of department, the supervisors, the city manager, the mayor, everybody was like, this person has to go. You know, and we took a decision that this is totally out. So the service to that person, because of the nature of the person, you know, and the inherent danger that he posed, we effected the service to that person via a Metropolis. I think it was one vehicle with 2 officers that had to go and serve him. And it only happened once. That service was to service the termination when we sent junior Metropolis officials to go and serve him.
Yep. Thank you, Commissioner. Mr. Nciza?
Yes, ma'am.
My apologies. Could I ask you to turn to the next page, your final paragraph there, paragraph 122. I would invite you to read that into the record, please.
Commissioners, I have listened to the evidence of Chief Mapieye and Deputy Chief Spies before this commission. Viewed cumulatively and in terms of my own experiences, the commission is able to see a pattern whereby Dr. Mashazi, Mr. Shega, and Advocate Behari used labor processes, suspensions, special leave, disciplinary proceedings, even terminations, to frustrate and get rid of employees who opposed their unlawful conduct that relates to Brigadier Mkhwanazi at the time, up to the point where he became even the Deputy Chief of Police. There is an aspect that I'm not even sure that Chief Mapieye knows that I know this, but there's an aspect that our commissioners just want to bring to our attention that was relayed to me by 2 heads of departments in the municipality, who are still in the municipality. And the person is like, no, man, we went into a senior management team meeting. Senior management team meeting, commissioners, is the city manager and all the HODs in the municipality. It's supposed to be a meeting that discusses strategic issues about service delivery, implementation of resolutions of council, mapping processes that must be implemented to ensure that the citizens of Ekurhuleni are better served. And this person says to me, you know, we went into a meeting where for about 45 minutes, the discussion was about Mapieye and Mkhwanazi. Like what? Yes. Where Mapieye was lambasted from start to finish on why is he not able to work with Mkhwanazi, and told that whether you like it or not, you will work with Mkhwanazi. If you don't want to work with Mkhwanazi, you better leave. So these HODs expressed the frustration to say, how can we go to an SMT meeting and we must sit there and listen to this type of engagement? And the poor chief was stunned. You know, both of them are like, he was like, no, ma'am, it's fine, we will work. No. I know that you hate Mkhwanazi. You know, I stopped you from doing this nonsense that you wanted to do against Mkwanas. You and your species were an alima burwa. You and your white men, 2 senior people, experienced that. And when we talk about this relationship, and this is soon after Mkwanas was appointed as Deputy Chief of Police, you know, and this is at the point where indeed Mapie, as he had testified, was still having problems about how that appointment had been effected. And then it gets lambasted in the senior management team meeting that is supposed to discuss how we must deliver services. That meeting became about Mkwanas and why Mkwanas must be treated as the Prince of Ekurhuleni.
Thank you, Mr. Nciza. We have then reached the final topic in your witness statement, paragraph 123. It's titled Impact on My Life. I'd invite you to make some remarks to the Commission on this aspect.
Commissioners, the impact on my life that this whole ordeal has had has been rather devastating. Professionally, my standing in the local government sector has been severely dented by this experience. As much as I was the divisional head employee relations in Ekurhuleni, but I was also the provincial chairperson of the Salga Human Resource Practitioners Forum, which also made me the lead or chief negotiator of the employers in local government in Gauteng, you know, which is a role that I had held in the sector for more than 10 years as the chairperson of that forum and leading negotiations on behalf of all the municipalities with the trade unions in the bargaining council Gauteng division, Central Gauteng division. Of course, except for Tshwane and Johannesburg. I don't want those colleagues to say that I represented them. I represented all the other municipalities. These 2 municipalities had their own divisions where they negotiated. But I was also the leader of the employer in Ekurhuleni on negotiations with organized labor since 2003. In December 2022, I had received a 20-year recognition award for my contribution to the bargaining council in terms of its establishment, its progression into a fully fledged bargaining council, its engagements in terms of stabilizing the local government sector. You know, I was one of the people that was actually awarded for my 20 years service in the bargaining council because I served in the executive committee of the bargaining council at the national level. I've served, and at the time of my dismissal, I was still a member of the employer party in terms of the bargaining committee at the national level. I was also the chairperson of the technical advisory committee of the bargaining council, a committee that dealt with processes of how the rules in the bargaining council are to be implemented, the appointment of commissioners. You know, I was the chairperson of such a committee. But the treatment that I received sought to annihilate my career just because people had to protect a criminal enterprise. Personally, the impact on my wife, my mother and my children, as well as my broader family, has been immense. Because, I mean, when this whole thing erupted in 2023, my name was brandished all over the place. I was in newspapers, I was on TV, you know, people had issued statements about my suspension and all sorts of things. So my family then had to now respond to a situation that was created to place me as a person of questionable integrity. And indeed, my family has been stigmatized by the flagrant lies that have been spewed, impugning my image and standing in society. Communally, this ordeal had resulted in an attempt to remove me from ministry in the Anglican Church, whereat some congregants had invoked a process of a petition due to the lies that have been spread and the falsehoods that have been spread regarding my name. A petition was then lodged with the office of the Bishop of the Anglican Church in the Highfield Diocese, seeking to remove me from all ministerial positions in the church. At the time, I was a church warden in a parish, and I'm also a lay canon, which is an advisor to the bishop in the Anglican Church. So a petition premised on a notion that I had been dismissed for fraud and dishonesty, was then submitted in an attempt to indeed make me sever my ties with the church. And this was all because of the shenanigans that are happening in the city of Ekurhuleni.
What came of that attempt, if you don't mind saying?
Cool heads prevailed. Cool heads prevailed. As much as there was that petition, I was summoned to the bishop's office. I sat with the dean of the cathedral, and we had I think 2.5-hour conversation where I was able to also, without getting into the type of detail that I've gone into in these proceedings, but just to alert and highlight to him the intricacies that are involved, and the fact that what is in the newspapers is not always what is actually prevailing, unfortunately. And quite honestly, commissioners, everything that had happened to me, I don't believe that if I was not in the church, I would have been able to survive it. The fact that I was suspended, fortunately, the rector of my parish at the time held a meeting with me because my name was all over the place, called me into a meeting. We had a 3-hour session, one-on-one, and that then provided me with a pillar, and I poured my life, my time, my resources into devoting myself to the service of ministry in the church. And that soothed my spirit.
Ms. Nciza, when you address 128, I'd like you to address the reasons given for your dismissal. You will recall that one of them was you did not provide the advanced diploma in labor law, but the second one was that you did not sign your contract of employment. So when you deal with that, can you just address those reasons and whether or not they were valid, or if they were used as a smoke screen, whatever your view is, can you just address the reasons for your dismissal as set out in the dismissal letter?
Thank you, Commissioner. Commissioners, first let me start with the issue of the contract, non-signing of the contract. Fortunately, in the course of the arbitration proceedings, I submitted an unfair dismissal dispute to the employer, then said no, there was no dismissal. And they alleged these are the funny things that Advocate Behari does. There was an allegation that there was no employment because I did not sign the contract. The commissioner in the proceedings said, but signing of a contract is not a requirement for the existence of an employment relationship, you know. And the reasons why I did not sign the contract are well known to the employer. My second contract, my first contract I had signed, it was perfect. My second contract had issues, and I said, no, but I can't sign, correct these issues, you know. And I submitted to Xolani's office, you know, for some reason they were not corrected, but this was usual in the municipality. There's quite a number of even HODs. There's an HOD or 3 HODs that I know of that had not even signed their contracts, even though Section 57, especially for HODs, is very clear that if there is no signed contract within 60 days, then the offer of employment is withdrawn and therefore the relationship is terminated. But this is now, in respect of myself, 20 months down the line, you know, the issue that there is no signed contract was raised as a basis upon which I'm terminated. But if you look at the letter that we have requested, Commissioner, where there is the call for representations, the issue of the unsigned contract is not raised to say that make a representation on this. See, so make a representation why the contract is not signed. And then on the issue of the so-called non-submission of the advanced labor law, there was a submission of the advanced labor law, commissioners. Firstly, UNISA had provided, because I had lost the certificate around about 2009, we had applied, and then they provided a record, a transcript to say that this gentleman, Xolani, Mr. Nciza, you have done this course, you have passed the exams, indeed, you have the course. And they even indicate the mark I had gotten in the exam. And then in 2022, again, UNISA issued a similar letter to say that, no, you've got this. Now, the argument that effectively gets raised is to say, but this communication from UNISA, as much as they are from UNISA, the academic institution that you went and did the course at, and surprisingly, I was part of a cohort of employees, 20 employees of the municipality that went to do the advanced labor law program at UNISA. We didn't even register ourselves. We don't even have student numbers. It was a workplace skills program in partnership with UNISA to do the course, paid for by the city of Ekurhuleni, administered on our behalf by the city. We did not even go to campus. The lecturer went to the municipality and lectured us in a lecture room of the municipality. Beautiful arrangement. I then get dismissed that I don't have that course, even though everything was submitted to the municipality and all the records. So indeed, when this thing was becoming hot as it was, I communicated again with UNISA, and I copied Xolani in all my communication to say, UNISA, you know what? As much as you've given me these documents and you've given the municipality these documents, the municipality still insists on a certificate. And the people at UNISA then said, okay, fine, do these processes. We are going to issue with the replacement certificate. And Xolani is copied. And the person who signed the termination letter, Maseko, is also copied. On the 20th of March, UNISA then submitted a replacement certificate. That replacement certificate was then also sent. What they did, they emailed and then indicated in the email that they're also sending a courier to my house with the replacement certificate. So I took that email and I sent it to Xolani and Maseko to say that this thing that you're complaining about, here it is. 2 days later, I got dismissed.
That certificate exists?
Exists.
So can you share it along with that letter that you referred to of 1 March?
Exactly.
Thank you.
Yes, we'll attend to that. Thank you, Commissioner.
Okay. So, paragraph 128, with all my dedicated service and accomplishments in the municipality, and I can assure you, commissioners, I have a lot of things that I've done for the municipality. I don't even think that I actually took you through my experiences where at some point I was held hostage. There is a point where there was a red tax fund that was established in an attempt to assassinate me in 2011, and all sorts of other things where indeed I have experienced a lot of attempts even on my life and my person as a result of me defending the municipality. I was suspended surreptitiously without even being afforded a contractual opportunity to advance representations to be heard. This matter is still to be finalized in arbitration proceedings. I referred a dispute in September 2023. Some 26 months down the line, I still have not been accorded justice. And primarily because the municipality has done everything to delay the matter. The initial team that was dealing with the matter, commissioners, to give you a picture of what has been happening, they had an advocate who had a pupil in the matter. Then they had an attorney who had a candidate in the matter. So he had 4 lawyers, effectively. And then that entire team is no longer involved. They started off, removed the attorney, and then the advocate. Now they have an attorney and an advocate, so 6. And then I was summarily dismissed without a disciplinary hearing for a qualification that the municipality took me to. The academic institution provided evidence of the qualification, but nonetheless, I was terminated. In this particular matter, they had an advocate and 2 attorneys in the dismissal matter. That advocate also dropped the matter. At some point, this matter commenced in March 2024. It is still ongoing as we speak as well. And again, all sorts of things have happened to make sure that the matter doesn't finish.
Is it before the bargaining council?
Yes, both of them are before the bargaining council. So you had 3 legal practitioners in the dismissal matter. In the disciplinary matter, you had 3. You had the attorney who was presiding, an attorney and an advocate. So all in all, the number of lawyers that have been used by the municipality in my matters are 12 attorneys. On top of the resources that were used to harass me, 12 attorneys. And I've only used a shop steward in all of them. My suffering was for one thing and one thing only. On numerous occasions, commissioners, Dr. Mashazi would accuse me of not being loyal to her. She has done this in front of the chief of police, the CFO, the CIO. She has indicated, when you are not loyal to me, I appointed you, but you are not loyal to me. And that is exactly why I find myself in the predicament that I'm in. I was not loyal to Dr. Imogen Mashazi. Thank you.
Thank you, Chairperson. That's the conclusion of Mr. Nciza's. My apologies.
Mr. Nciza, it's unrelated to this last part of your evidence, but it is touched upon.
Mr. Nciza, I'll quote to you something that was said by Commissioner Spies and then I'll put a question to you. On the 10th of November 2025, Commissioner Spies said the following: our disciplinary agreement has already been touched on. It deals with all municipal employees in exactly the same manner, irrespective if you are a plumber or an admin clerk or a police officer. We are dealt with in terms of that disciplinary agreement in that manner. I skip some parts of this evidence, and he continues. A municipal police officer is treated, does not matter what crimes they committed, they are treated as if they are a normal council employee, and they are not treated as if they are police officers, which can intimidate witnesses, and therefore the public does not want to come and testify in our disciplinary cases. I skip again. That is one of the problems that we have in this environment where we are dealing with officers. I end the quote there. As an expert in HR management issues, do you share Commissioner Spies' concerns about disciplining Ekurhuleni police in exactly the same way civilian employees are disciplined? If you do, why is that so?
I will deposit a response, Chair, by referencing something that the second Chief of Police of the city of Ekurhuleni once said. We were at a budget steercom meeting. Unfortunately, I'm an institutional memory person. This is around 2007 or so. And that Chief of Police was one Robert McBride. We're sitting in a meeting, we're dealing with the budget issues, trying to make a determination of how to adjust the budget of the municipality. And the then city manager had problems with the submissions that were made by EMPD. And Chief McBride, as he was then, commented to the executive mayor, the late Dumangos. He says, Comrade Duma, this is not correct. I'm a policeman. I'm not going to be dictated upon by a civilian. This notion that police will be treated like any other department or like any other employees is nonsense. It must stop. We laughed.
And perhaps for context, parts of what I skipped say, this being said by Commissioner Spies, that with SAPS, the process is different.
It's different.
Please continue.
Yes. We laughed. I mean, it was Robert, but there is truth to what he was saying. And one agrees, and indeed, I know that the Chiefs Forum has raised this issue, and it is something that SALGA, as the employer organization, needs to zoom into. You can't have a one-size-fits-all arrangement. The police are in a command structure. They are uniformed service, the Metro Police. There is, for instance, a notion of you obey and complain later, whereas in the civilian structure, you seek consent. Employees will tell you that, no, I'm not going to agree to this transfer, I'm not going to agree to that. There must be some consent, there must be some agreement, there must be some procedure. And sometimes police require a different approach. I agree fully that indeed it's an issue that the sector must look into. This collective agreement that we are talking about has been extended to 2028. It expired in 2023, parties extended it, and then now they've extended it to 2028. I think this is an opportunity, such things that are actually going to be coming out of this commission. It's an opportunity that the parties in the bargaining council revisit their approach to collective bargaining in the sector. You know, I once made a presentation, Chair, to the effect that local government is a multilateral sector. We are not like your engineering services sector, because we have engineering services within local government. We've got health within, we've got police within. So there's a multiplicity of sectors in local government. You don't have it as a singular sector because we've got various occupations in the sector. So indeed, perhaps when we look at our processes, there is a need for us to identify that, recognize that, appreciate it, so that our collective bargaining approach is able to cater for the different functional dispensations that will then pertain to specific functions. You can't treat a Metro Police officer like a water services, like a plumber. A Metro Police officer and a plumber are totally different. You know, they're totally different. The environments in which they work is totally different. I totally agree that indeed the issue is in the approach that the employer must adopt in the negotiations. I know organized labor would prefer a situation when there is a singularity of processes, because it's their members that they seek to protect, but it's not protecting the citizenry and it's not protecting the sector itself. So I want to agree with it.
What exactly within a command structure, as I think you referred to it, dictates that the processes must be different? You, right at the beginning, you referred to the fact that the nature of the environment within the police is one of a command structure. And what you said then seemed to flow from that structure. So what I want to understand is what exactly within the command structure dictates that the process should be different, as you suggest, as you and Commissioner Spies suggest.
The police structure, Chair, you can't you can't have room for insubordination, for insolence. You can't have room for situations wherein a commander's command can be subjected to question. Because the problem that you're faced with is these people deal with serious issues where indeed lives can be at risk, lives can be at stake. You know, so if indeed in a command structure, the commander would not have the authority because he must be subjected to certain processes, you know, because now those that is commanding cannot actually have got leeway or have got room to challenge the command. And they've got room to challenge the command because, hey, I'm going to submit a grievance. If you do this, if you instruct me like this, if you're commanding me to move from this deployment to that area, because sometimes you find that the levels of crime and the levels of what you call of risk to the community differ, and therefore you need to move resources and move them with immediate effect. And people tell you, but you are transferring me, you are doing this to me, you know, and my terms and conditions of employment require that you must consult me before you can transfer me. And if you're going to transfer me, you know, this. That is what a normal employee raises, and that is what we are faced with even in Metro Police, where indeed, because as much as they're in a command environment, but they've got the rights and everything that accrues to a normal civilian worker. Now, then your command structure is compromised. You know, it's a command structure. There are instances wherein indeed decisions that are taken by the commander must be implemented with immediate effect. Otherwise, we are not able to respond to life-threatening, to risky situations with immediacy. You know, that's where I find the challenge.
And lastly, again, right at the beginning of your response, you said within this command structure, it's a case of obey and complain or challenge later.
Yes.
Why do I seem to think or recall that there's something that police are entitled not to obey an unlawful order? I may be wrong, but it's something we can check because it's a question of law. It doesn't really require evidence. But I'm asking you, or I'm engaging you on it because you mention it in the context of saying it is justified to have a different process for police. So why do I seem to recall that there's something that says exactly what I've said?
You are correct, Chair, that indeed where the instruction or the command is patently unlawful, you know, an officer would have the right to disobey it at the instance of the instruction being issued, you know, as opposed to follow it and then, because if indeed the command is that shoot this person and the person is unarmed, the person has not done anything, and the instruction is that commit murder effectively, you know, then we not excuse an officer because it was an instruction from a superior, you know, because that is patently unlawful, you know, but I'm transferring you. You know, there is nothing unlawful about transfer. It might not be procedural, and therefore you would want to lay a grievance or do whatever, but if indeed there is a basis upon which I'm saying as a commander that you need to move, as much as you are deployed or are located in precinct A, but the situation requires that we need you at precinct B. You know, as much as you might not agree with it, but we need you because the situation calls for it now. You can go to precinct B. That is what is obey and complain later. You go to precinct B, and then you submit your processes. But you go to precinct B and you perform as instructed at precinct B. You know, otherwise, if indeed you allow that a policeman will say no, because he's citing that no, there is a labor process that must be followed before I say yes. I need to consult with my union, which will be available next week. And then the union, when it comes to the meeting, and then they're going to require that you give them these further particulars about the risk assessment that you've conducted, why you need more police officers. I mean, yeah. And that time, the people at precinct B, you know, the residents that must be serviced by precinct B are suffering.
Thank you, Mr. Nciza.
Thank you, sir.
Maybe firstly, just as a follow-up to this discussion, Commissioner Spies said, and his words was, it has been presented, this issue has been raised at the highest level in Salga. And then he used the words, and I want you to maybe explain if you know anything about it. And then he says, but to date, we have been denied that. Now, the question is, has this been debated and rejected at Salga, or it's simply a matter of it has been shelved and all he was conveying was it hasn't yet been legislated?
Madam Commissioner, remember Salga is an institution of organized local government, and it deals with the many facets that inform local government. Indeed, Commissioner Spies might have had that discussion in one area that deals with community safety processes in local government. from an HR working group perspective, like I indicated that one even made a presentation in Gauteng, where indeed we're talking about the multilateralism of the sector and the need to differentiate in terms of our terms and conditions, in terms of our processes, in terms of our discipline management processes and all sorts of things, to differentiate amongst the various categories and occupational arrangements. So their process as the cluster of community safety and the likes might have raised the issue, but at a national collective bargaining level, the issue has not actually taken root yet. And before you can even get to that point of the collective bargaining regime, the employer body as SALGA, inclusive of the HR components of SALGA, must first come to a determination that as the employer, we want therefore to advance this multilateralism of the conditions of service, inclusive of discipline management, as informed by the various occupational categories.
Thank
At
you.
this point, we have not gotten there.
It hasn't come up yet. Lastly, Commissioner Spies also testified to 3 police officers who are in Brigadier Mkhwanazi's section who have appeared in court, and he did name them. This is Stolz and
Mackenzie and Twala.
yes, and this relates to the matter of Smokes and King's supermarket where cigarettes and someone was kidnapped. Now, his testimony was that did get to a disciplinary process being instituted, but then the matter was taken away. I think there was an appeal supposed to start on day 1, and he attended to testify. And then he says that when he got there, he was told it had been taken away, and nothing's ever happened about it. Do you know the circumstances in which this would have happened?
I did testify on this, Madam Commissioner, I think sometime early yesterday. We had appointed effectively the same disciplinary committee that we had appointed for Brigadier Mkhwanazi as well, Now, I testified earlier on that the presiding officer, withdrew from the matter, citing non-payment of his invoices by the municipality on other matters, and unfortunately, this happens in August, and I get shipped out. I got shipped out, so as I understand it, no other presiding officer was then appointed,
Thank you. Thank you, Mr. Nciza. Thank you, Ms. Mutlaseta.
Thank you, Chairperson. That's the conclusion of Mr. Nciza's evidence this afternoon.
Thank you very much, Mr. Nciza.
Thank you, sir.
Thank you. Who do I look to?
Chair, we proceed normally at 9:30 tomorrow morning with the next witness.
Let's adjourn until 9:30 tomorrow.
Yeah.